Hello, everyone. Welcome to today's LinkedIn live session, where we will be diving into one of the most critical topics of our time, India DPDP Act and emerging trends and challenges in data privacy. I am Damodar Sahu, co-founder and chief growth officer at Data Safeguard, and someone deeply passionate about the intersection of technology, privacy. Joining me today is guest Dr. Amar Patnaik. Welcome, Dr. Patnaik.
Thank you, Damodar.
Dr. Patnaik is a thought leader in institutional economics, a former member of parliament, and a member of India's Joint Parliamentary Committee on the Personal Data Protection Bill. He is also an accomplished author, auditor, with a rich background in economics, finance, and data policy. Together, we will explore four pivotal aspects of data privacy. One, the intersection of data privacy and institutional economics. India's Digital Personal Data Protection Act, we call it DPDPA. Lessons from global frameworks like GDPR and CCPA. And the last one, the role of AI in shaping the future of data privacy. Let's get started. Uh, Data privacy today is not just about technology or compliance. It's deeply tied to institutional structures and social norms. Organizations, economics provide us with a lens to understand how organizations adapt to evolving privacy frameworks. Dr. Patnaik, your work on institutional change is fascinating. How do you see the relationship between data privacy and institutional economics? For instance, how do you think shifting power dynamics in a organizations influence how privacy is perceived and regulated globally? But before that, I would request you if you can talk about the recent India DPDP Act tabulated. You can start with India DPDP, of data privacy and institutional economics.
Thank you, Dr. Damodar. Thank you so much. Uh, the question that you have asked is very profound. In fact, it is the intersection of the privacy law, which is a new law, not just from the point of view of being a recent enactment, but also from the point of view of the fact that it actually changes the whole paradigm of the way we look at citizens' control over their personal data. In fact, when I spoke about it in Parliament while the bill was getting passed, I did mention that it is one of the most important kind of enactments in independent India. Why did I say so? I did say that because privacy earlier, if you look at the historical development, initially, individual privacy right over his data was not recognized, mind my word, not recognized by the Supreme Court of our country, of India. But over a period of time, the need for respecting individuals' privacy in terms of his personal data was getting recognized by the constitutional court and was getting slowly built in several judgments into our working, into the functioning of both government and the private sector. But the landmark judgment, which really changed everything, and as I said, that was a paradigmatic change that happened in 2017. There are two judgments, but it came close one after the other, one on the heels of the other, and that is the Puttaswamy judgment. The Puttaswamy judgment basically made privacy a fundamental right. It was read into the right to life, and therefore it was considered that it is a fundamental right of citizens. mind you, in fact, fundamental rights are not just of citizens, but by any person. So any person will be protected by the Constitutional Court and, in fact, the Constitution uh, by reading it into the existing fundamental rights. So Article 19 and Article 21, right to life, Article 21, and freedom of expression, Article 19. Now, these changes, this change brings in a new culture into our working in the country, as I said, both in public and private sector. It basically says that individuals have a choice over their data, and they choose to decide whether to share the data or not. And data, I'm using the
Yeah.
word data quite loosely. Basically, it is personal data.
Right.
Non-personal data can be used for innovation, can be used for any purpose by data users, or as they say, the data fiduciaries. But in case of personal data, what has been mandated is that you need to take the consent of the data principal or the person who is having the data before acting on it or before processing. Now, when you take consent, there are two things that has been brought in there, that this consent has to be understood by the person who is sharing the data. It's an informed consent. The second point is that which is a kind of defining thing in our act which was passed, which is not there probably in any other jurisdiction, is the fact that this consent, while seeking this consent, the data principal will be given the option to exercise it in any language, Indian language that he understands, which is scheduled languages. So the consent which is to be obtained, it has to be simple, but it has to be in the language in which he understands. The second point is that the purpose has to be stated. So there is a purpose limitation. If you're collecting the data for a particular purpose from the data principal, you cannot use it for a purpose other than what has been stated and other than the one for which consent has been taken. And after taking the consent, the data has to be protected, the storage has to be protected, the processing of the data has to be done in a manner that is not detrimental to the data principle. There is an accountability
Yeah.
framework. So this data, the entire Data Protection Act, which was passed in 2023, and the rules, draft rules, which have just come out
Yeah.
3 days ago, are basically derived from the concept or the theme and the principle that has been set out in the Puttaswamy judgment. The historical the recent historical work on that is that after the Puttaswamy judgment, the government of India appointed a committee, Justice Sri Krishna committee, to suggest a draft act form, and then the government worked on it, introduced a bill in 2019. I was a member of the Joint Parliamentary Committee that discussed the bill, but it was hugely imported from the EU GDPR, which was the gold standard at that time. But then we realized that India has different socio-economic conditions. The context is different, and India is, one of the biggest components of India's growth story has been the digital growth,
Right.
using digital methods for driving the economy, and therefore that has to be protected, and that cannot be killed because of introducing privacy conditions and privacy norms. I am not going to get into the various finer aspects of this act and the draft rules, which we could do at a later stage. But to your
Yeah.
question relating to whether what is the intersection
Yes.
between institutional change, which is my PhD work, and
Yeah.
this, which is a very interesting question which you've asked. Nobody has asked me this question so far. Is the fact that institutions are basically defined as rules of the game. Now, when the rules of the existing game, as I said, was that privacy is not as important. The individual's data could be taken by government, it could be taken by private sector, whether available in the internet or available even manually, and could be used in any manner. But
Yeah.
the change that is happening, and that is why the rules of the game changed, is that now everyone has to, anybody who is collecting his individual's data has to respect his privacy, and therefore has to seek his consent, state the purpose for which it is being used, and will retain the data as long as the data principal wants. If the data principal wants it to be erased after a period of time, then the data fiduciary has to do it. So this change which has happened is an institutional change, because the rules of the game has changed. And this has happened because there are various ways in which the institutional theory tells you that things can change, and that is through three methods basically. One is coercive methods or regulatory changes. The other one is, the changes because there are standards standard setting organization prescribes that everyone has to change, and therefore they change. And the third one is at the cultural cognitive level. Now, what this has happened is this spurred by a regulatory change. So the regulatory change has brought in this institutional change. But what is going to happen is that in order to have an ecosystem where everyone respects the privacy of an individual's personal data, and therefore while collecting has to follow these norms and procedures which has been set in the act, would require a change not only by some standard setting organizations which might come up later, including the government, but at
Yeah.
the cognitive level as well. People have to have it in their mind, in the frame, mental frame, that if I am taking a data, including a photograph, then
Yeah.
I have to take his consent, and I also would have to respect his privacy, that if I am going to take that data for the purpose of X, then I cannot use it for Y. So the institutional change that is being brought in is a full kind of wholesale upheaval kind of change in the way we looked at personal data and the way we process personal data of citizens, Indian citizens. And the framework that has been given here is basically aiding that particular institutional change. And like in any other change, the change will always be initially probably painful, would probably require massive changes in organizations' way of doing business, way of handling customers' data, vendors' data, way change the way they process that data, and change the way, let's say, the big tech companies, they collect huge amount of data.
Right.
They don't state the purpose for which this has been collected. They will also have to change. So it would require a huge change in the organizational culture, in the organizational processes, in the business processes, and also in the delivery of government services as well, because government is also the largest data fiduciary.
Absolutely, absolutely, absolutely. No, no, well said. I love the point of view you have talked about the intersection of data privacy and institutional economics. Thank you so much. And also, you have covered nicely on the India DPDP Act. As you know, I represent Data Safeguard, and we are into AI-powered data privacy management solutions, including we have seen how the DPDP is reshaping the conversation with the Indian business. We are talking to hundreds of enterprise in India. Many are grappling with questions like, what does the consent mean to the Indian context? How do the SMEs, implement compliance cost effectively? While the DPDP creates a strong foundation, it also opens the door to global collaboration, and it is exciting time to think about the role India could play in setting privacy standard for the rest of the world, right? So my next question, we'll talk about a little bit on the global data privacy compliance, and I know you are the best guy to talk about that. So let's pivot to global framework like GDPR and CCPA, California Consumer Protection Act. So these regulations have set high benchmark for data privacy. For Indian business operating globally, the challenge is definitely navigating this complex framework while staying innovative, right? So, Dr. Patnaik, what lessons can Indian business draw from these frameworks like GDPR and CCPA and other regulatory compliance and privacy law? Are these specific aspects of GDPR or CCPA that you believe that Indian companies or Indian enterprises should prioritize as the adapt to DPDPA?
Yes, during the several sittings of the Joint Parliamentary Committee, and I can tell you the Joint Parliamentary Committee sat over a period of 2 years,
Yeah.
and we had about 2,000 depositions from organizations. So 2,000 organizations invited, all across the entire spectrum of possible data fiduciaries in the country. And at that time, the as I said, the standard was the EU GDPR. We're looking at it,
Yeah.
and the CCPA was of course there, but America per se didn't have a separate country-wide pan-US data
Right.
protection law. Then we also were cognizant of the fact, as members of parliament, as people's representatives, as to what are the problems which are singularly applicable to India, which are concerns for India or Indian citizens, which are typical to Indian data principles or Indian citizens, and also operationalization of the act. What would it require for Indian data fiduciaries?
Yeah.
So keeping those two things in mind, the idea was that it should not be overly compliance driven like the EU GDPR.
Yeah.
And therefore, even though we have taken some basic principles from EU GDPR in the new act, we have not made it overly prescriptive. We have made that the basic principles will remain, will have overriding effect on separate sectoral regulators who may come out with separate regulations, because privacy requirements and norms could be different for health sector, could be different for agriculture sector, could be different for education sector. So the Indian data protection law, therefore, is a landmark regulation from that point of view, that it is a principle based, very simple, it's very written in very simple language, a legislation which would not require too many amendments to be brought in and each time to come to parliament. The prescription part of it has been left to the to the rules. So the rules which have come, draft rules, contain some amount of the prescriptions, which is there in the EU GDPR: right to erasure, right to be forgotten,
Yeah.
child gating, age gating of children's data. Now the principle is there in the main act, but the rules give the prescriptions. There is a next level. When the data protection board eventually is set up, they will come out with their own regulations. So that would go down further as to how to operationalize the functioning of this particular act across the country, and how will be organizations be doing it. So I think it's a very graded method. I think this is better than the way UGDPR was structured. And I can tell you this much, that during my interactions with many European, lawmakers as well as think tanks, they think that the Indian law balances the need for privacy and innovation much better than the EU GDPR. To that extent, the CCPA probably is much less reliant on compliances, upfront compliances. What the Indian law now does is that it helps the startups and the MSMEs to not be overly burdened for implementing the provisions of the law. They, as long as they are small, they are not declared as significant data fiduciaries, they could still operate with less of compliance, and therefore compliance costs, and it would be easy for them to innovate. And I think this is very important, and I must compliment the government for it, because
Yeah.
India's current growth story is being driven by innovation, has to be driven by innovation, and will be driven by innovation. And many of these innovations will be digitally driven. So unless we give this particular leeway to them, then they will be overburdened. The
Hmm.
idea, however, is that an environment of trust has to be. Why do you get in regulations? Basically, to build trust. So the trust between the person sharing data and the person collecting the data would now get established in our country, and I think this is a phenomenal thing. We must all celebrate this. There would be hiccups, I'm sure. There will be probably several iterations to the draft rules once we start implementing. Hopefully, the regulations will take care of some of them. So some of them will would require changes in the rules. But you see, India is a vast country. There are different kind of data principles. There are data principles in rural areas where the digital literacy is minimal, and they would still be required to abide by this. And when you ask them for informed consent, it may be difficult. But then we have brought in the innovation, in fact, in the law itself, by saying that you need to give them an option to exercise their consent in their local language. So overall, I would think that we have taken the good things of the UGDPR. The basic principles remain the same, which is accepted across the globe, and we have made it a proper balance between innovation and compliance-driven privacy. If you ask me whether this is adequate, I would still say no. It's dynamic because technology is developing, and individuals' perception of data as to what is personal data and what is not personal data is changing. And lastly, I would say that it is the right time now for India to bring out a non-personal data legislation, because that would really spur innovation, because people would know that this is the data they can use for building different models, AI-based models, non-AI-based models, different applications in different sectors, and will actually complete the process.
Correct. No, well said. Thank you for your insight. And you utter AI. So my next thing would be AI and data privacy. And let's say AI is both an opportunity and a challenge for privacy. I mean, data privacy. So in one hand, AI can enhance compliance through automated data audits or anomaly detection. In the other hand, it raises ethical questions, right? How do you ensure fairness, transparency, and accountability in AI ecosystem, and that to AI in data privacy? At Data Safeguard, we are leveraging AI to address synthetic fraud, privacy risk, but this journey requires constant vigilance. So, Dr. Patnaik, I would like to understand, how do you see AI reshaping the privacy landscape, and what guardrails should we as a society put in place?
Very deep question, and we have to deliberate on this, because AI is the toast of the town, toast of the world, and it is delivering significant benefits to different cross sections of people. There are no doubts about it. But it's a double-edged sword, and therefore the point that you mentioned, that implementation of AI-based applications requires the algorithms to be trained on huge amount of data. The data itself may not be, itself free from bias, pre-existing bias.
Dr. Patnaik?
Issues relating to cost considerations. There are issues relating to societal fissures. Now, the data collected initially would reflect that. So when a AI algorithm is trained on such data, then such biases, such discriminations could probably get accentuated. So policy decisions based on such models could actually make these biases and these discriminations, in fact, much more severe, and exacerbate the divide in society. So we have to be careful of that. Now, the data privacy law, which has been brought in, will...
I think some technical glitch. Dr. Patnaik, I think he'll come back.
Can you hear me?
You are back. You are back.
I was briefly logged. I was briefly locked out. So so there is a need for data fiduciaries and people like your organization who are doing tremendous service, yeoman service in addressing issues relating to cybersecurity, concerns relating to synthetic frauds. Uh, when you develop an application in the Indian context, the context would require to be cognizant of this pre-existing biases and
Right.
discrimination. Unless you do that, the
Hmm.
trust will again diminish between the data principal and the data fiduciary. So that is something that one has to address. But the point is, technology always
Right.
gallops for ahead of regulations.
Yes.
It is always the regulations always are lagging behind the
Hmm.
technological revolutions or technological diffusions, and therefore the idea is that India, the authorities should be cognizant of this fact, and therefore changes in, let's say, generative AI, what are happening, the data which is being collected and is being trained on. Sometimes it may not be possible to take the consent of the data principal, because you never know who is the data principal whose data
Right.
is available in public domain. Now these consent have to be addressed. However, the basic principle remains the same, that between the law is basically oriented towards protecting the fundamental right of a data principal. So
Yes.
if technology is galloping in such a manner that it violates the data this fundamental right, then I'm sure this will be brought to question in the constitutional courts.
Mhm.
And therefore, the government should be very quick to bring these changes in the regulations in such a manner that it doesn't break this trust, and also put the technological revolutions in a kind of jeopardy, and uh, innovation gets stymied in the process.
Absolutely.
So I think the AI brings in several benefits. The idea is that if somehow the development of the AI ecosystem happens by remaining cognizant of this new law and new
Yeah.
legislation, then the trust between the data principal and the data fiduciary, the person who is collecting the data and giving this solution through AI models, will remain intact. And ultimately, isn't that what we want? Because if we want a adoption of AI to happen, AI
Yeah.
based systems or AI based innovations to take place, then the trust must remain intact. Otherwise, people will not use it. Uh, but it is a difficult question,
Yeah.
difficult thing to achieve. And therefore, my personal prescription is privacy by design should be the principle of development of any AI based algorithms, whether it is large language models, whether it is small language models,
Yeah.
or whether it is any application. That would actually give an edge to the AI based regulation. And whoever is developing, since you people are at the forefront of providing solutions for implementation of the Indian new Digital Data Protection Act through AI models, and in a very modular fashion, as I understand.
Hmm.
You have taken a giant step, and I'm sure you are cognizant of this. And
Yeah.
industries, organizations who will eventually have to be compliant with this law, lest they are dragged to the constitutional courts, would probably be advised to do well to adopt the kind of applications that you have developed, because it's
Absolutely.
already compliant to the new Indian Digital Data Protection Law.
Absolutely. Absolutely. Thank you, Dr. Patnaik. It has been an absolute pleasure discussing these critical topics with you. And from institutional economics to AI, today's conversation has underscore one thing: data privacy is not just about compliance; it's about trust. Like you said in your remarks, right? Ethics and innovation. And to everyone watching this time is to act now. Whether you are entrepreneur, policymaker, or tech enthusiast, data privacy must be part of your core strategy. Privacy by design, Dr. Patnaik focus on that. So let's work together to build a future where technology and privacy go hand in hand. uh,
Absolutely.
yeah.
Absolutely. Thank you so much, Damodar. It's been a very thought-provoking session, And in a short period, I think we have covered a large canvas of thoughts in this live seminar. And I know that the last word has not been said. Things will change and would require changes in our thinking, changes just as there will be the policymakers would be required to think in terms of changing not only the law but even implementation. I firmly believe that data privacy is the cornerstone of a sustainable digital economy in our country, and I think we have to all, face the challenges, embrace it with responsibility and optimism, with the idea that the environment grows with each player trusting the other, and the legislation providing a framework for
Yes.
developing and in increasing this trust among various stakeholders. Thank you so much.
Thank you, Dr. Patnaik, and thank you all for tuning in. Stay connected, stay informed. Let's continue this vital conversation further. Have a great
Thank you.
day ahead.
Thank you. Thank
Thank
you
you,
so
Dr.
much.
Patnaik.
Thank you.
Yeah.
Thank you.